Thank you. Mr. President, I'd like to first thank Senator Mary for her steadfast leadership in the fight to protect women's health care and for arranging this time for us to speak this afternoon. The legislation we're debating today is just the latest salvo in the far right-wing assault on a woman's constitutionally protected right to an abortion. With all due respect to my colleague from Nebraska, who introduced this legislation, this bill is a solution in search of a problem. Contrary to what the proponents of this bill argue, it is and has always been a crime to harm or kill newborn babies. And people guilty of this crime can already be charged and prosecuted to the full extent of the law. Let's be clear. The Senate isn't debating this legislation today because there is an epidemic of infanticide in this country. There is one. There is not one. There isn't one. I can hardly say it because it's really not happening, and so therefore this bill is a solution in search of a problem. Instead, we're indulging the majority's use of a false premise to inflame the public, shame women, and intimidate healthcare providers. When you strip away the ultra-conservative rhetoric, you're left with a very simple argument from supporters of this legislation, that the moral judgment of right-wing politicians in Washington, D.C. should supersede a medical professional's judgment and a woman's decision. Conservative politicians should not be telling doctors how they should care for their patients. Instead, women, in consultation with their families and doctors, are in the best position to determine their best course of care. In talking to healthcare providers in Hawaii, I've heard how this legislation and other bills like it in states across the country could force them to provide care that is unnecessary or even harmful to patients. The Hawaii section of the College of Obstetricians and Gynecologists made this point persuasively in testimony recently submitted to our state legislature's House Committee on Health earlier this month. In opposing similar so-called born-alive abortion legislation heard in Hawaii State's legislature, which didn't make it out of committee, by the way, the group of doctors wrote, and I quote, "We are physicians who provide compassionate, evidence-based care. By criminalizing healthcare providers, this law may actually reduce the number of healthcare providers, not just the surgeons, but anesthesiologists, nurses, midwives, office staff, willing to provide this care." But again, that is the actual intent of this bill. Reducing access to safe abortion care would threaten the health of women in Hawaii. We are the physicians who care for patients when they find out that their very wanted, very loved baby has severe fetal anomalies. Families sometimes choose to end the pregnancy and provide their baby with palliative care rather than subject their baby to any suffering or futile efforts at resuscitation. These families face very difficult decisions about what their values are and what is best for their family, decisions that none of us has a right to make for them or judge them for. What they need in these moments is compassion and medically accurate information from healthcare providers free of judgment or politics. End quote. I couldn't agree more, and it's why I urge my colleagues to oppose this legislation. In just a few minutes, I expect the Senate will defeat this bill because it will fail to win the required 60 votes. Nevertheless, the threat to women's reproductive rights is intensifying in states and courtrooms all across the country. Over the past few years, states have enacted hundreds of laws that harm women's health and violate their constitutional right to an abortion. Mississippi enacted a prohibition on abortion after 15 weeks of pregnancy. Texas, Alabama, Arkansas, Kentucky, and Ohio have passed laws banning dilution and evacuation, D&E, an abortion procedure used usually during the second trimester. Indiana enacted a bevy of new abortion restrictions, including a law requiring every woman seeking an abortion to have an ultrasound, talk about invasive, and mandated she wait 18 hours after the ultrasound to have an abortion. And Louisiana passed legislation requiring abortion providers to have admitting privileges at local hospitals. This law would result in only one abortion provider in a state of 4.7 million people. Advocates have recognized the harms these laws would have on women and have filed suits to block their implementation. Several lower courts have ruled these restrictions unconstitutional, and the cases are moving steadily through the courts of appeals en route to the Supreme Court. The Fifth Circuit, for example, will hear an appeal of a lower court's decision to block Mississippi's 15-week abortion ban, as well as an appeal from Texas to allow its ban on D&E procedures to go into effect. The Seventh Circuit upheld a lower court ruling striking down parts of Indiana's mandatory ultrasound and waiting period law. The Indiana Attorney General has requested the Supreme Court to review this case. And the Supreme Court's temporarily stoppage of Louisiana's so-called admitting privileges law from taking effect on a 5-4 vote. This is the law that I talked about before. This law would result in one abortion provider in a state of 4.7 million people. The Fifth Circuit will now hear an appeal on the merits of the law, which is virtually identical to a Texas law the Supreme Court struck down in 2016. That was only a few short years ago in the landmark Whole Women's Health versus Hellerstedt decision. The stakes in these court battles, or the more than 20 other abortion-related cases making their way through the federal court, are incredibly high. Any one of them would provide the opening for the United States Supreme Court to finally fulfill the right-wing goal of overturning Roe v. Wade. It is with this central goal in mind that Donald Trump, Majority Leader McConnell, and complicit Republicans in Congress have been working to pack our federal courts with ideologically driven judges groomed and handpicked by ultra-conservative organizations like the Federalist Society and the Heritage Foundation. Donald Trump has already confirmed 85 judges, including 30 to circuit courts and two to the United States Supreme Court. These judges comprise 1/10 of the federal judiciary, with many more to come. In fact, a few weeks ago, the Senate Judiciary Committee voted 42 judicial nominees out of committee in one markup, and this 42 comprises an additional 5% of the federal judiciary. Less than 2 weeks ago, Justice Kavanaugh issued a strong dissent in the earlier mentioned Supreme Court's 5-4 decision to block Louisiana's anti-choice law from taking effect. Using tortured reasoning, Justice Kavanaugh essentially argued that the Supreme Court should disregard its own precedent from only 2 years ago. That is the Whole Woman case that I referred to. Just 2 years ago, to allow the Louisiana law to take effect. His dissent signaled his strong antipathy to a woman's right to choose, just as his dissent in Garza v. Hargan did when he was on the D.C. Circuit. His dissent as a justice this time demonstrated the emptiness of his promises to uphold Supreme Court precedent during his confirmation hearing. Justice Kavanaugh's promises then to follow precedent is like that of other Federalist Society-picked Trump nominees now packing our courts, offering little reassurance that nominees, in fact, will set aside their strongly held ideological views to be objective and fair judges. Another case likely to make its way through federal courts in the months and years ahead is a challenge to the Trump administration's new gag rule. This rule prohibits doctors and other clinicians participating in Title X family planning programs from referring patients for or even speaking about abortions, even if their patients request such information. Nearly 20,000 Hawaii residents receive reproductive health care through Title X. That's roughly the population of the city of Kapolei on Oahu. This attack on Title X-funded agencies like Planned Parenthood is an end run of Congress after Republicans have tried and failed dozens of times to end funding for Planned Parenthood. Planned Parenthood provides health care for millions of low-income women, men, and young people under Title X. Why do we persist? Why do the Republicans persist in trying to cut funding for Planned Parenthood? Mr. President, the constitutional right of millions of women across the country are under serious and sustained attack. But even in these not normal times, I do see some hope. As state after state passes laws to limit access for a woman's right to choose, communities like Hawaii's are coming together to protect such access. Last week, I joined activists and staff from Planned Parenthood of the Great Northwest and the Hawaiian Islands as they opened their new medical center and administrative hub in downtown Honolulu. I was particularly energized to see how many young people, women and men, were there and engaged in the fight to protect our right to choice. I've learned over the years that battles we fought so hard to win never stay won. It's up to all of us to stay engaged and keep fighting for our constitutionally protected rights.